Frederick Aiken, the defense counsel for Mary Surratt at the trial, the one who really does the heavy lifting, has a very interesting background and a bit of a mystery that I'm not sure we will ever be able to figure out. Some historians say that he studied law at Harvard. Interestingly, the Harvard Alumni Association says they have no record of him ever studying at Harvard.
He married the daughter of a judge, and so apparently he studied with his father-in-law, and that's how he entered into the law.
And in March of 1865, he and Clampett do open a law firm in Washington, D.C. They advertise that they're lawyers, and when the trial then comes in May of 1865, Reverdy Johnson associates Aiken and his partner Clampett in the defense of Mary Surratt. Why did Reverdy Johnson pull out of defending Mary Surratt is a very interesting question, and I don't think can be completely answered. A couple of thoughts. Reverdy Johnson, very prestigious, considered to be a crackerjack defense counsel. He argues vociferously that the military commission can't try Mary because she's a civilian. The war is over, and his legal argument is very sound. But prior to doing that, one of the military commission members had challenged Reverdy Johnson's patriotism, had indicated that he really wasn't a Union man and really shouldn't be there. And Johnson was really offended. This is an age of personal honor being taken very, very personally. And there's every reason to believe that Johnson may have stopped defending Mary because he was disgusted and he felt he'd been insulted by the military commission. He may also have stopped defending her so well and given it over to Fred Aiken and his assistant because he thought Mary was guilty. Fred Aiken's defense of Mary Surratt has come under criticism over the years from historians. I think it's actually ill-placed. His defense was good. He starts out in his argument by saying, don't let your desire for revenge commit an injustice here. And that's his theme, which I think is exactly right. And then he says, Mary may have committed some acts, but the government hasn't proved she had a criminal intent. Looks like she's in the wrong place at the wrong time. Okay, she drove out to Surrattsville on the day of the trial, but that was for another purpose. There's no criminal intent. And he does play to the jury's belief that a woman simply wouldn't do this. I think he went to Judge Wiley because he realized this was a legal avenue that was available to save his client from hanging. Good move as a lawyer. One question would be, well, why didn't he do it earlier? Honestly, I believe Aiken sincerely thought that he'd won the case for Mary at trial, or at least he was not going to get a death sentence. Historians pretty much agree that Aiken was surprised that Mary had been sentenced to hang, and so I think that's one reason that he waited until the end to get the writ from Wiley. Did he think that his client was innocent? There's plenty of evidence that he could have thought she knew about the conspiracy to kidnap, but do nothing about the conspiracy to murder. So I think he may have said, well, she's certainly innocent of what they're charging her with, and she doesn't deserve to hang.